This week, on Thursday, people witnessed one of the most landmark judgments of the Apex Court in the past many years. The judgment, which came with a majority, has ruled that states in the country have the power to subclassify scheduled castes and scheduled tribes, and this is not in contravention of Article 14 of the Constitution. Now, the question is, what does this landmark judgment actually mean for the people on the ground, those who are members of the scheduled castes and scheduled tribes, and how is it going to impact the society, the politics, and these particular communities? To understand the nitty-gritties involved in this very important judgment, we have a special panel of guests with us this evening. But before I introduce them to you, let us quickly listen in to what are the actual highlights of this benchmark Supreme Court judgment.
On Thursday, Supreme Court gave a landmark order which affirms subclassification of scheduled caste and scheduled tribe categories. This judgment by a 7-judge bench is expected to go a long way in giving social justice to those who have remained marginalized and deprived even after reservations. These are the highlights of the benchmark order. Subclassification of SC/STs is permissible under Article 14. Supreme Court order rules by majority that SCs and STs are not homogeneous group, they have inequalities. States have the power to subclassify scheduled caste and scheduled tribe groups. This 6:1 judgment overrules Chinnaya judgment of 2005. Justice B.R. Gavai said states must identify creamy layer criteria for subclassification. Chief Justice Chandrachud said classification must be substantiated by quantifiable and demonstrable data showing inadequacy of representation. Justice Bela Trivedi dissented from the order and said that this is the prerogative of the centre or precedent under Article 341.
So those were the main highlights of this very important judgment. Of course, it's a very detailed judgment and it will take a while for all of us to understand the complexities involved. But to discuss some of these major highlights, I have here with me Desh Ratan Nigam, well-known advocate, also a political analyst. You have been listening to him on Media Scan on earlier occasions. Namaskar, Desh Ratan Nigam.
Namaskar,
welcome.
Namaskar.
Also with us online, Shashank Shekhar Jha, another advocate known for his constitutional understanding. He will be able to help us go down this judgment and the major issues involved here. Welcome, Shashank Shekhar. Namaskar.
Namaste.
And I'll come to Desh Ratan Nigam first. Sir, you have seen what are the major highlights of this landmark order. Now, I'll start with, some of the issues that have been raised as a point of criticism in this over this judgment. And the most important criticism, which Justice Bela Trivedi has also raised, and a lot of commentators are, raising soon after the order came, that this is not what was actually, understood and laid down under Article 341, because it is the President or the Union, if we may say, which has the sole powers to determine who are the scheduled castes, and classification has not been laid down there.
Well, Smita ji, let me tell you, the beauty of law is that it evolves over a period of time. Did our framers of Constitution or Constituent Assembly thought about giving reservation to OBCs? No.
No.
It subsequently came. So as the time changes and evolution takes place and new circumstances and facts develop, the law has to catch up with it. And this is where the interpretative role of the Supreme Court comes into the picture. Because a law may have been made. Reservation for scheduled caste and scheduled tribe was provided in the Constitution. And further realizing the fact that the Supreme Court notices that the empirical data shows that the two categories of reservation does not have that homogeneous nature of backwardness. There are levels of backwardness, and therefore the trickle-down effect of reservation in public employment is not reaching to the last person in those particular castes and tribes. Therefore, this particular judgment has come with 6:1 majority, and saying that it is not a homogeneous class. There has to be a subclassification to identify inadequate representation based on the backwardness, and subsequent.
And Chief Justice has specifically said that there are inequalities.
Yes.
It is a reality.
Yeah, it's a reality.
Within the SC or
Yes,
ST fold.
yes, and generation after generations, few people have been cornering reservation, and the real benefits that actually must reach the last person has not yet reached. That is what the empirical data which was before the Supreme Court has shown. And therefore, subclassification, they said it is permissible within the SC quota. And subsequently, the identification has to be done based on some rational criteria, demonstrable data, and there has to be substantive equality, not formal equality.
I'll come to the rationale of the classification and how it can be, how it can be substantiated, the classification and the subclassification. But before that, I want to come to Shashank Shekhar here. Shashank Shekhar, two very, very contradictory views have come out. The Supreme Court ruling very clearly says that scheduled castes or scheduled tribes are not a homogeneous whole. Inequalities have been found within their categories, and therefore subclassification by states is permissible and it does not contravene Article 14. Now there are two questions here. Number one, whether it goes against Article 341, and number two, whether scheduled caste being one homogeneous whole is a point that the Supreme Court should have left untouched. Your take.
Namaste, Smitaji, and your fellow panelist. Smitaji, I guess, like my fellow panelist was saying, that law is evolving. And in a country like India, we need to understand that every day is a new day. Now, before answering to your question and understanding whether 341 was touched or should not have been touched, we need to understand that this ruling has overruled the 2004 judgment in the E.V. Chinnamaya case.
Correct.
The earlier judgment of Supreme Court has stated that any subclassification of scheduled caste would violate Article 14. That is right to equality of the Constitution of India, and that the only Parliament could make changes to the presidential list under Article 341.
Yes.
However, the Punjab government contended at that point of time that 2004 judgment did not apply to their situation, and that is why thereafter a 5-judge bench led by Justice Arun Mishra referred the bench matter to a larger bench. Now, this is the larger bench of 7 judges. And what does this judgment bench say? This majority verdict from this bench says that the emphasis on the need for quantifiable and demonstrable data by states to justify subclassification can be allowed. The court underscored that states must not act on whims but base their decision on solid evidence. The bench
Okay, so let us go step by step, Shashankji. Number one, can the states have the power, seeing that it is the president, which means the parliament, who is the sole, deciding authority in this case?
Yeah, the good part here is that court has explained as to how they will distinguish the data. When OBC came, and thereafter after Supreme Court judgment, when the layer came, creamy layer versus non-creamy layer, it was for the states to divide whether a particular subcategory falls under creamy layer or non-creamy layer. Now, as far as scheduled caste and scheduled tribe is concerned, Article 341 says that presidential order will be required, Parliament will do the justice. Even recently, Patna High Court did the same judgment with regards to the category which will be falling under scheduled caste and scheduled tribe.
Yes.
The only liberty which has been granted to the states are that they make now subcategorize those caste and tribes among, between creamy layer and non-creamy layer. Now, we need to understand why this right has been, or this power has been derived to the state. It is because every state has different caste and different tribes. So central has a state, however the creamy layer and non-creamy layer will differ from state to state. So suppose a particular category, and I will name, so suppose Yadav community or Meena community, Meena falls under tribe. So in some place it falls under some other category. So it may be a very rich category or a very upper category in one state, however it may be a backward category in some other state. So that is why this particular thing has been granted to the states to determine which will fall under creamy layer and which will not fall under upper creamy
so
layer.
I'll come to these questions about deciding the creamy layer, how will it be done, and also the question of how will the classification be done.
Smitaji, just one thing.
Yes, quickly.
Just one. Yeah, very quickly. So here in this case, it is very important to understand and note the undertaking or the stand taken by central government. According to Article 341, all the rights and liberty of SC and ST category resides with center. However, center took a stand in this case, and it is very historic. Center supported the sub-classification, arguing that it is essential to address the varying degree of socio and economic backwardness within these groups. And that is why Justice Gogoi
Attorney General was very categorical in making the point that this should be done from the center's stand. But I'll now want to come to, some of the reactions that have emanated, immediately after the judgment came. So we'll just play out a couple of reactions for you, and then we'll carry on with this discussion.
This will lead to the real social justice and will pave way for taking care of the suppressed people. This is not against any community.
मंडल आयोग डिफाइंड है, संविधान में डिफाइंड है, कोई नई चीज नहीं। माननीय न्यायालय ने उस बात पे मोहर लगाई है और माननीय न्यायालय का अभी पूरा फैसला नहीं देखा, कहीं ना कहीं इस बात का जिक्र जरूर आया होगा कि आखिर इतने सालों से आरक्षण होने के बाद भी भागीदारी क्यों नहीं मिल पाई।
So those were a couple of reactions. Venkaiah Naidu, former Vice President of India, making it very clear that this will now pave the way for real social justice, because there are several communities and castes, despite having reservation for all these decades, they have remained marginalized. And we have seen reactions coming from some castes like the Madigas, several castes in Tamil Nadu, and also some tribal communities in other parts of the country who have expressed a lot of joy after reading this judgment. Their leaders have expressed happiness. I'll come to Desh Ratan Nigam here. Sir, very clearly, it seems that despite decades of, having the quota officially, there is a very, very big chunk of scheduled castes and tribes who remain where they were, because these, the benefit of quota, as you were saying, has been cornered by certain communities who were upwardly mobile and perhaps quicker in benefiting from the reservation.
Yes, Smitaji, this issue is beyond politics. This is about poverty, this is about backwardness and empowering the people who are not so empowered. Therefore, the focus has to be on those people who have not got the benefits of reservation and who have remained marginalized, as you have rightly pointed out. And therefore, this is a very welcome step. Why should they be, after decades of independence, be left behind? That is why a lot of people are welcoming it. However, those probably interested in politics are opposing it, who wants to use these poor people, as merely a vote bank to be utilized during the elections and then leaving them behind.
No, on this point, sir, I'm sorry. Don't these other communities, irrespective of the fact whether they have benefited from quota or not, they are as much voters in the country as the other types?
No, they are. But this is not about their political rights. This is about upliftment of certain sections of people who are still marginalized. Therefore, they have to be brought into the mainstream of entitlements that they rightly have, which the Constitution framers and the Constituent Assembly and the Constitution already provides them. But yet it had not reached them. Supreme Court has only done what that reservation must reach them. They have not decided that the reservation should be there or not there. Within the reservation, they have said...
That is the domain of the legislature.
That is the parliament or the legislature that would decide. Here they have said that sub-classification is permissible because SC/STs are part of backward classes.
Okay, I'll take a quick reply from Shashank, and then we'll see some more reactions of political parties. Shashank, do you agree that there are a big chunk of communities within the SC and ST fold who have remained deprived and marginalized, even though the Constitution gave them the benefit of quota?
Undoubtedly. However, see, initially when SC/ST quota came into existence, it was based on the theory that those categories or those castes or those tribes who are into a professional or into a particular employment or particular profession, they are falling under the same category. Now, Supreme Court has said that the time has changed and people, because of SC/ST categories, goes into top positions, and that is Justice Pankaj Mittal have categorically stated, and I will quote: if any member of the first generation has reached higher status through reservation, it should not be extended to the second generation. I guess this is one of those classic sentences which everyone in this country believes. Be you support reservation or you don't support reservation, you will always want the backward class to come forward. And how will you do it? You will have to ensure that those who did not get it should have it. Now, however, here one more important aspect. Justice B.R. Gavai has highlighted one more point. He said
I'll come to B.R. Gavai. We'll have a quick conversation, especially on Justice Gavai's observation. But before that, can we just listen in to some of the political voices who have very clearly criticized the order?
पॉलिसी हमने अंग्रेजों के समय से सुनी थी, डिवाइड एंड रूल। मुझे ऐसा लगता है कि ये जो एकजुटता शेड्यूल कास्ट शेड्यूल ट्राइब के लोगों में हो रही है, उसको तोड़ने के लिए डिवाइड एंड रूल की पॉलिसी को इख्तियार किया जा रहा है।
मिल्कियत जाने बगैर बंटवारा नहीं हो सकता, यानी अनलेस यू हैव द सब्सटेंशियल डेटा विथ रिगार्ड टू ईच कास्ट, देयर सोशियो इकोनॉमिक स्टैंडिंग, हु स्टैंड्स वेयर इन टर्म्स ऑफ रिप्रेजेंटेशन, अगर वो सारी चीज़ें नहीं जानेंगे तो मैं समझता हूँ इस तरह के सब कैटेगराइजेशन की बातें मुझे बेमानी लगती हैं, अर्थहीन लगती हैं, भावविहीन लगती है।
So, Deshratan Nigam, two things here. I'll come to both of the arguments one by one. It is a ploy, a political move to divide the scheduled caste community so that they do not, assert themselves as a homogeneous whole. And this is following the British formula.
Smita ji, this is a very fallacious argument in the sense the divide already exists between those who have already reaped the benefit within the reservation and to those who have not been able to reap those benefits. So those who give this kind of an argument opposing it want that divide to continue.
No, but if leaders or political parties who, basically come from the SC or ST community and claim to represent them, if they are not convinced with this order, will there not be a problem in implementing it at the grassroots?
Let me, Smita ji, tell you, this is a political argument, and in politics, if there is a large section of people which are still deprived and the leaders are not very considerate about them, then the new leadership will come out from the people who are deprived, is still not getting benefit.
Right.
It is that threat that the established leadership of these communities is facing, that they will start demanding, and that particular section will throw up new leaders. That divide, they don't want to be covered. That privilege that they have already earned, they don't want to lose that, and therefore the divide already exists. Supreme Court judgment wants to, cover that divide.
Right. So what Mr. Nigam is saying here is it is not the fear of divide and rule. It is the fear of perhaps becoming irrelevant because new leadership is, likely to emerge. But Shashank Shekhar, coming to you, I want to, elaborate on what Manoj Jha has just spoke while giving his reaction. He says, how can you make any policy or give any order about any community unless you have enumerated, you have the data? Now, the Supreme Court order, the CGI, to be specific, said there is no need to go door to door or every citizen to citizen. What the state governments can do is they can gather the quantifiable data by which they will be able to prove that certain caste or community, they can substantiate that they have been discriminated upon, and it should not reach 100%. It should be proportionate as per the discrimination. Now, in simple layman's language, what does this mean?
I will add to what my fellow panelist was saying. Actually, this particular judgment will make those caste-based politicians irrelevant. I guess Supreme Court judgments have categorically covered all those aspects. What Justice B.R. Gavai has highlighted was that the necessity of this ruling by stating, and I quote, "State must evolve a policy to identify creamy layer among the scheduled caste and scheduled tribe So it is, and they are saying that you should not follow what is being followed in OBC, because OBC, or that is other backward class, is very different from scheduled caste and scheduled tribe. So that category, and Supreme Court has not taken this in their own hand. Supreme Court has given this power to the states, and center actually supported states stand here. And why it was required, I will give a very small example. You take this example of Punjab and Haryana, because these all started from Punjab and Haryana.
Yes.
Punjab and Haryana has very low margin or low number of people from scheduled tribe category. However, as per Supreme Court's previous judgments and Government of India's rule, Parliament's rule, the preservation for scheduled tribe is 7.5%. And you have very significant lower population. So that means you are doing injustice to some other category. That is why this is very much required, that you form this categorical creamy layer versus non-creamy layer.
Yes, understood. Coming back to Mr. Nigam, sir, the Bihar government in state government institutions long back under the leadership of Chief Minister Nitish Kumar introduced a special category called Mahadalits, and state government has been giving benefits to them, where particularly those 21 scheduled caste Dalit communities are benefiting from it, who were found to be not have benefited from the scheduled caste quota all these decades. So in a way, this is already being tried and implemented in some parts of the country. So certainly there are no constitutional questions, really serious questions involved.
See, the constitutional question involved here is reservation only. Subclassification is only to promote the objectives of reservation already provided in the Constitution. So there cannot be a contradiction.
No. So are you saying, for the benefit of our viewers, are you saying that, once the bottom line of reservation is understood, anything beyond that can be done or not done? That margin, that leverage is there.
Reservation is a broad policy so far as CSTs and OBCs are concerned. Now, how to achieve the objective is the government to decide, and here the Supreme Court has said that subclassification can be done based on the level of backwardness.
So
and
this
that
is a matter of detail.
Yes, further detail, and to see that the last person who has not got the benefit must receive the benefit. In fact, it promotes the objective of reservation provided in our Constitution.
Fine. Shashank Shekhar, coming back to you for the last question very quickly. We have very little time left with us. Many people, including people like the Bahujan Vikas Aghadi and political parties, or not parties but organizations who claim to represent scheduled castes and tribes, have said that they will appeal for a review of this order, even though it is a 7-judge bench order. So you think maybe we have not really seen the last word on the whole issue?
So this will not be the last word for sure, because like I said earlier also, society will keep evolving. So what is correct now will be changing 5 years later. However, we must understand one thing. The tallest leader ever in India from scheduled caste category was Dr. Bhimrao Ambedkar Sahab. Dr. B.R. Ambedkar said that he wanted reservation for this community so that this community can get benefit. Now, did this community get benefit? Yes, because now we are seeing that they are on influential position, they are rich, they are coming from rich category, they are UPSC administrators, they are politicians, etc. And these are the benefits of that reservation. However,
so how will the creamy layer be determined? Considering the leaders are saying that, if you go by the creamy layer and you try to bring some people out of the reservation fold, then it is not really justified, because this is a question of dignity, not just prosperity.
This is sheer political standards, I would suggest. Here we need to understand that the parliament, especially the Lok Sabha, it has 545 members. BJP, that is central government, has already taken a stand in favor of this. Congress has taken a stand because Punjab government is theirs, not theirs, but it previously was theirs, and now
At the time of the petition, yes.
Correct. Chandrababu Naidu from Andhra Pradesh has especially supported this. So I feel that out of 545, over 500 or 540, you have already the support. So as far as parliament number is concerned, you have full support, and they represent the majority of this country. So we need to understand that those who are opposing it will be looked like a sheer political opportunity and nothing more.
Fine.
And
last word to Deshratan Nigam, just in one line, what do you think will happen in the coming days?
See, the fact is, anybody has a right to review. That's the statutory right or the constitutional right that they have. However, it's a very good judgment. It upholds the reservation and also the objectives of reservation, which are still yet to be achieved, so that the last person standing must get the benefit.
Thank you, Deshratan Nigam, for those last words. And clearly that it is the intention of everybody in the country, the judiciary, the legislature, the governments, that those who officially were given quota on paper but did not practically benefit from it should finally now, after we have completed 75 years of independence, be able not only to benefit from it, but join their other brothers and sisters in the progress of the nation. Gentlemen, Deshratan Nigam, Shashank Shekhar Jha, thank you very much for joining us at such a short notice. Thank you, Mr. Nigam, for coming to our studios. And Shashank Shekhar Jha, thank you for explaining all those complexities so well. From the political reactions that have emanated immediately after the order, it appears that there may be a lot of political back and forth following this landmark judgment. But what the Constitution bench has made very clear is that those who did not benefit from reservations in the past so many decades, it is finally the time for them to get the benefit of it. And this might bring a ray of hope to a lot of marginalized castes and communities waiting to join the nation in its path to progress. With that, viewers, it's a wrap-up on Media Scan for this weekend. Do join us next weekend for another important issue of national significance. Till then, namaskar.
Why has India been targeted